What if a 5-year-old child could be sued for moving a chair? It sounds unbelievable, but one ordinary summer afternoon changed American tort law forever. Welcome to Law Review Hub, where landmark cases become unforgettable stories. This case is about Garratt versus Dailey. It was the summer of 1955 in Washington state. What began as an ordinary afternoon between a young boy and a family friend would soon raise a legal question that courts and law students still discuss today. At the center of this story was Brian Dailey, a boy just 5 years and 9 months old. Like many children his age, he was curious, energetic, and completely unaware that one ordinary moment would eventually bring his name before the Washington Supreme Court. Visiting that afternoon was Ruth Garratt, an elderly family friend. To her, it was just another quiet summer visit. She had no reason to believe that an ordinary moment in the backyard would soon change both of their lives. At first glance, there was nothing unusual about the chair, just an ordinary wooden lawn chair, sitting quietly in the backyard. But within moments, it would become the center of a legal debate that continues to shape tort law today. As the afternoon continued, Brian quietly watched the backyard around him. Then he noticed Ruth walking toward the chair. It was an ordinary moment until it wasn't. As Ruth drew closer, then Brian moved the chair just a short distance, a movement that lasted only a moment, but would later become the central question before the Washington Supreme Court. For most families, the story might have ended there, but this one didn't. Instead, the incident found its way into a courtroom. The case was brought before the Washington trial court. The facts of the accident were largely undisputed. The lawsuit was based on the tort of battery, but battery is not simply about causing harm. It also requires intent, and that single word would determine the outcome of the case. The accident was over, but the legal battle was just beginning. Ruth Garratt filed a civil lawsuit against Brian Dailey, claiming that he had committed battery. Did Brian intend for this to happen, or was this simply the thoughtless act of a young child? The answer would determine whether battery had occurred. Inside the courtroom, the facts were not the real dispute. Everyone agreed that Brian had moved the chair. Everyone agreed that Ruth had fallen. The real question was something far more difficult. Brian was only 5 years and 9 months old. Could a child that young legally form the intent required for battery? That was the question before the court. The trial judge concluded that Brian had not acted with the necessary intent. Judgment was entered in his favor, but the case was far from over. Ruth Garratt appealed the decision. The case was taken to the Supreme Court of Washington. There, the legal analysis changed completely. The court explained that intent does not require a desire to cause harm. It can also exist when a person knows that a harmful result is substantially certain to occur. That distinction would become one of the most important principles in American tort law. The Supreme Court did not decide that Brian was liable. Instead, it ruled that the trial court had applied the wrong legal standard. The case was sent back so the proper question could be answered. When the case returned to the trial court, the judge found that Brian had known, with substantial certainty, that Ruth was about to sit where the chair had been. This time, judgment was entered in favor of Ruth Garratt. She was awarded $11,000 in damages. Garratt versus Dailey became one of the most influential battery cases in American tort law. It clarified that intent may exist, even without a desire to cause injury, if the actor knew the result was substantially certain to occur. Sometimes, the most important legal principles emerge from the most ordinary moments: a quiet afternoon, a simple chair, a 5-year-old boy, and a question that continues to shape the law. Thank you for watching. If you enjoy exploring the cases that shaped modern law, Subscribe to Law Review Hub and join us for the next landmark case.